Equity and pay transparency. So pay equity, you're probably quite familiar with. I'll talk to you a little bit about what pay transparency is and why that's so important. And I did this work through the New Brunswick Coalition on Pay Equity. We developed a worksheet or a workshop. We sought community input, and we drafted a model law for New Brunswick that's modeled after PEI. So with respect to pay equity legislation, it always comes as a shock to me that not all provinces have pay equity laws. We have 6 provinces that have them: Manitoba, New Brunswick, Nova Scotia, of course, Prince Edward Island, Ontario, and Quebec. So we have other provinces that are working on policies but haven't quite developed legislation. And Alberta has neither passed pay equity legislation or has a pay equity policy framework. Of course, all human rights codes across Canada have human rights legislation that say that you can't discriminate in relation to pay, but there's not the kind of proactive pay equity process that other provinces have. And of course, most provinces that have pay equity laws, it only applies to the public sector, and that's also the case in Atlantic Canada. It's something that the coalition has lobbied to extend, for example, to big institutions like my institution at the university. So far, we've not been successful. So there's quite a few gaps in there as far as pay equity legislation. And I'll talk to you later about becoming good sex and gender equality ambassadors. So that is one thing that you could possibly do, is talk to anyone that will hear you about pay equity. The pay gap currently in Canada is 89 cents on the dollar. It's a little bit higher in places like New Brunswick, mainly because our wages are lower than the rest of Canada. And there's still quite persistent inequities between women and men. The UN Human Rights Committee has expressed concerns to Canada, the International Committee rather, about the high pay gap in Canada, especially in relation to the low-income women, Indigenous women, and racialized women. And in fact, in OECD countries, Canada lags behind. It's about the 8th worst. We do slightly better than the United States, as a matter of fact, who's the 9th worst. And what this shows is that pay inequity basically affects women through all walks of life. It starts from teens having their first jobs, and it goes all the way to retirement. So women basically retire with 80% of the retirement proceeds that men have. And a lot of that relates to motherhood and mothering. And there is quite a bit of impact. Having a child decreases a mother's wages by about 5 cents an hour compared to women without children. But even women without children have a wage gap of 10%. Oftentimes the wage gap is blamed on women wanting to work part-time or stay home with children, and that might be part of it, but that isn't all of it. And other arguments that I've heard is, well, that just reflects women's preferences, but the data also shows that a lot of the pay gap represents discrimination in employment. Going on to pay transparency, this is basically employers disclosing what people in their organization make. So PEI in the Maritimes is kind of our model. It's just passed pay transparency legislation in June 2022. And there's some fundamental components of pay transparency. It's things like specifying in law that you can't retaliate against employees for asking about other employees' pay. You have to include a pay band on your job ads. And there's also things like um, proactive reporting that is not included in PEI, but the Ontario legislation that hasn't been proclaimed has that. Um, and as well, I forgot to mention, it's it prohibits employers from requesting pay information from job applicants. Now, what does that all do? Interestingly, if you look at the data, pay transparency has a pretty significant impact on reducing the pay gap. You wouldn't think, and I was frankly quite surprised that it would have such a significant impact. Even things like not asking prospective employees what their previous pay was, because that just perpetuates whatever pay inequality is in the system, but also advertisement and including pay bands. And having employees that are already in the company see what new employees might be getting for pay allows them to ensure that they're being paid equally. It also has benefits for employers. It increases the quality of job applicants. It ensures that there's better fit between applicants and employers. So all of these things, and for employers as well, once pay becomes transparent across an organization, a lot of problems in the system come from unconscious bias. And this transparency helps employers. They gather all the pay data, and it allows them to kind of have a bird's eye view on discriminatory gender-based differences that can't be explained by things like valid merit factors. So if I can go to the next slide, this is some other stuff that I've been working on in the recent, over the past year or so. One of the things that I've been working on is the extreme intoxication defense. And this is where I'm going to get into a little bit of constitutional law and women's rights. So there was a case called Brown that the Supreme Court brought down in, I'm going to say, May 2022. And that struck down the prohibition against using voluntary extreme intoxication as a defense against what's called general intent offenses. And these include everything from manslaughter to assault to sexual assault, which was the primary basis upon which that law was put in place. People on the call might remember the Davio decision from 1995, where a very drunk man sexually assaulted an elderly neighbor. In the Brown case, however, that prohibition was struck down as being unfair to male accused persons. And the Government of Canada quickly put a criminal code provision to replace it, but one that has its own problems. And myself and Professor Elizabeth Sheehy from the University of Ottawa did some data crunching on the numbers of those who accessed extreme intoxication. Even after the prohibition was put into place, it was still being referenced by courts. And what we saw is there were 86 cases between 1995 and 2001, which referenced the extreme intoxication defense and the criminal code prohibition, section 33.1. 40 of them involved what could be considered traditionally violence against women, assaults and sexual assaults against intimate partners. And another 40 or, well, 20 or so involved other female victims, so that when you were looking at who are the victims of extreme intoxication, 63 out of 86 were women, and all of the accused perpetrators were men except for 6. So it's a very gendered defense. Now, the new provision more explicitly requires mens rea and voluntariness, but it includes its own problems that the accused person must have been able to reasonably foresee that their over intoxication would result in violence. So National Association of Women in the Law has spoken out against the current iteration of the bill, and we were just heard before Senate and House of Commons committees about changes, so hopefully we'll see that coming. The next one I wanted to talk about is some work that I've been doing on coercive control. And so if you can click on the slide again, Andrea. Coercive control, I'm not sure if very many of you would know what that is, but it's an evolution in our understanding of violence against women. And violence in terms of physical violence might be perpetrated only rarely within an abusive relationship, but there is a relationship of eroding women's independence and autonomy, breaking down their personality so that they become utterly dependent on their abusers. It's very similar to tactics used by prisoners of war, actually. Evan Stark is the clinician that developed that theory. And if you look at the mass casualty inquiry and Lisa Banfield's testimony, the girlfriend of the shooter, it is very, very clear that she was being subject to coercive control in terms of the perpetrator controlling her access to employment, controlling even her cell phone and her car so that her whereabouts were under his control at all time. And in the past, courts really haven't recognized that kind of control as a part of the pattern of violence. It would take physical violence for a court to recognize that. And with coercive control, it might only be perpetrated a few times in that relationship, more to punctuate and result in the woman being fearful. It's only meant to remind her that he has that ability to hurt her rather than being a common pattern in some cases. So now we have the definition of family violence in the Divorce Act, recognizing coercive control as violence. There's also a new private members bill that would criminalize coercive behavior, and it's based on UK legislation where this has been passed with some success. The next element I want to talk about is Clare's Law. And this is laws that are being passed. New Brunswick law was just passed in December 2022, and it allows women that are at risk in men that have a history of abuse to be able to receive information about that risk from authorities. And in New Brunswick in particular, applicants can go and inquire and receive a risk assessment and contextual information. They don't get the full disclosure of criminal convictions, but even police can alert women and suggest to them that they go and receive this information, which is just given verbally. It's not written in anywhere, but it's just to better ensure women's safety. And apparently the places in Canada where it's been passed, Saskatchewan, Alberta, they're reporting very positive results from that. But in the Maritimes, as I said, New Brunswick has just passed it. I don't believe Nova Scotia has such a law. So that is something that remains for us to be worked on. The last one concerns Bill 21. And this is something that I've devoted quite a bit of my research time to. And it relates to the religious symbols law in Quebec. So not only do you have to have your face uncovered to give or receive government services, but certain members of the government cannot wear any religious symbols at all. And what the data has shown is that it's mainly Muslim women who are school teachers that are being discriminated against in their employment. Which is permitted under Bill 21, and Bill 21 also invokes the notwithstanding clause, which would include the law continuing to operate despite the general equality provision, despite freedom of religion, for instance. But the part of the charter I study is section 28, which guarantees equal rights to male and female persons according to its text. And what I argue is that this denies Muslim women equal access and equal right to religious freedom. Section 28 is not subject to the notwithstanding clause. It was very intentionally so. So this is before the Quebec Court of Appeal right now, and will likely go to the Supreme Court in terms of whether Section 28 actually has the power to strike down a law that invokes the notwithstanding clause in relation to, like I say, Section 2, 7, 15 as well. Okay, so I'll move on to the next slide. This is another issue I've been working on, and this concerns regulation 84, says 94 on there. Sorry, that's a typo, 8420 in New Brunswick, which indicates that abortions that are performed outside of hospitals aren't funded under Medicare. And so for instance, in Fredericton, we don't have a hospital providing abortion care. North of the province as well, there's very limited access. So the government essentially thumbed their noses at women and said, if you don't like the current situation, go and litigate. And so we did that. A lot of the media attention was due to the fact that we had a freestanding abortion clinic in Fredericton called Clinic 554. That clinic closed due to a lack of funding. And that was one of the sparks for the litigation. One of the other issues connected to that I look at is the Canada Health Act and its requirements of accessibility and comprehensiveness, which also relate to abortion access. Andrea, if you can just move the slide. But not only abortion access, there's been other issues with gynecological access. And I understand that this is also an issue in Nova Scotia in terms of diagnosis and treatment of ovarian cancer, various gynecological cancers. And the question is whether or not the Canada Health Act is being applied and complied with in a way that recognizes sex equality and gender equality. I should note that in relation to New Brunswick, one of the excuses behind not funding clinic abortions was that the government did not want to support privatization, but there's just been a law introduced that would allow a panoply of medical services performed outside of hospitals and within clinics in order to reduce some of the pressure on the system. Okay, I'm going to turn very, very briefly now to some of the best practices for law firms. And this comes from, research that I've done in my past life with the Canadian Bar Association. And also, I continue to keep up on the topic. And these are kind of, I'm probably not telling you anything new under the sun, but perhaps there's some new information for you there. So the first best practices that I talk about is being a champion. And you probably all know that we are at parity or even over parity for women in law schools and perhaps in the first years of practice, but the real problem is attrition. And of course, discrimination is part of the story there in terms of the failure to retain women. But the thing I wanted to talk to you about is the human instinct to gravitate towards sameness and how this is factoring into things. And I highly recommend to you, it's a book from a few years ago. It's by Erin Reeves. It's called The Next IQ, The Next Level of Intelligence for 21st Century Leaders. And she's someone that came and spoke to the Canadian Bar Association. The book is published with the American Bar Association, so it's very particular to the law firm context, but she talks about the fact that a lot of the issues and barriers to women in law firms come from this neurobiological search for sameness. And humans are hardwired to search for sameness and to employ stereotypes because it allows the brain to take shortcuts, to evaluate risk quickly, to act quickly. So it's something that we're hardwired for. And when it comes to diversity, we need to really consciously move against that search for sameness. Erin Reeves talks about how it leads us to think we know things when we actually just think them. And she also talks about the majority of unconscious biases are actually biases for a particular type of person, for example, rather than against. It's what she calls comfort zone biases. So that is something that if you're championing a champion of diversity in your law firm, that you need to not only educate yourself, but also educate your brain as to how to overcome that search for sameness and to turn towards difference. And that segues to, this little notation about being a champion. And I'm pleased to hear that McInnes Cooper, we were talking about previously how diversity is integrated into the very senior management committees because diversity needs to come from the top. And when I'm referring to champions, these aren't just mentors, and we usually have affinity mentorship in the legal profession where women mentoring women, other affinity characteristics like race, mentorship. But what I'm talking about is champions, and it's not necessarily people from the same ethnicity and gender, but those who can promote the person from within the organization, connect them to clients, connect them to other lawyers that can feed them work. So that is an absolute necessity for people that have are connected, are authoritative to champion women. The next element of inclusion, um, we all know what gets higher pay in law firm, and gets you power in law firm, and that's who has the biggest book of business, who has the biggest clients, book of clients that are the most lucrative. So how does that happen that certain people get those lucrative clients and files? What the studies show is that those from dominant groups receive informal mentorship training. It's about going for drinks or going to play a round of golf, getting those kind of informal conversations that educate the younger lawyers coming up on how to find that kind of work. Whereas marginalized groups like women benefit from more formalized processes, benefit from leadership training, that because that training might not be happening informally because of people search out sameness, right? We search out people we feel comfortable with, and a lot of that comfort comes from similarity. So one should, and just to cap off on inclusiveness, we have to resist the temptation to locate the problem in women. And that's somewhat what came from the lean in kind of phenomenon, because we still see discrimination, whether intentional or unintentional or systemic, that is unremediated and unreported. And that's still a barrier to advancement. So we really need to continue to consider the structural barriers to equality. When I was in practice, there was the stereotype that men were the finders and women were the grinders, which may continue to be the case in terms of men having more success at rainmaking. I'm not sure. But one way that you can combat that perpetuating into lower pay and lower opportunities is consider shifts in who's getting the originating credits. If women are the ones managing the client relationship after it comes in, thinking about whether they should be getting credit for that. Another thing is performance evaluations. And I know that very well because I write a lot of reference letters, and I've had to kind of think about the adjectives that I use to describe women versus men. And what the studies show is women get effort adjectives like working really hard, very persistent, very, kind of the grinder metaphors. Men get the excellence adjectives, such as, incredible skill, incredibly intelligent. So think about that in performance evaluations, and think about that unconscious bias that might be there. So commitment. And what I wanted to talk about under that one is, the old saw that what gets measured gets acted upon. If you're going to do anything on diversity and inclusion, you have to know what's happening on the ground, and even tie compensation to the level of diversity, both in bringing people into the firm and retention. I understand that you already do some self-identification surveying, which is really important to see, especially longitudinally, what's happening over time for retention, but also doing diversity climate surveying is something that law firms should consider. And that will give you the quantitative and the qualitative data. what is going on. When people are able to report things anonymously about barriers, what do you find? And the one thing that is critical is to be sure that after you do the measurement, take action on it. People get cynical very quickly if they're asked to put themselves out there in surveying and nothing is done about that. So you should show your employees that you're taking concrete steps. And the last one is about passion. How do you get passionate about diversity and inclusion, especially perhaps if you're a member of a dominant group, if you're a white male, for example. And the temptation there is to promote the old saw about return on investment and the fact that diverse decision making and diverse players on a team will make for better decision making and better economic performance for law firms. And I was reading a recent article in the Harvard Business Review that talks about the fact that that's a very uh, superficial analysis of what diversity does for institutions. And it may actually be counterproductive because if a firm does a whole bunch of diversity initiatives but don't necessarily see the results in the bottom line, that might put those programs in jeopardy. So what they say is that it's not enough to have a diverse group. What you really need is a diverse group that trusts each other. And that's when it presents benefits, is that when you make the team cohere together, by building trust, by allowing people to be vulnerable with each other and ask the difficult questions where they feel that people won't look down on them or judge them for asking hard questions, or brainstorming and thinking of different ways of coming at a problem. So when you don't have that kind of team building, you find that diverse teams might actually lead to more tension because there might be a lack of trust there and differences might become more pronounced. And dare I say it, I was a cynic, but Brene Brown also has a book called Dare to Lead. And I'm not a touchy-feely person, so I was very skeptical at picking it up, but she has some very good tips on leadership in terms of how to cultivate that kind of vulnerability. And it doesn't mean over disclosure and that you have to kind of lay out all the story of your life, but she talks about how vulnerability is about being daring, talking to employees, frankly, about challenges that companies face, and ask employees if they have questions that they want or what support that they need, and asking people to stay connected with one another. So perhaps I will leave it at that. I have another slide concerning allyship and legal practice. I'll just touch very briefly about it. Trauma-informed lawyering. I have a newspaper column and I wrote about coercive control, and I can't tell you the number of women that emailed me saying that she wished her lawyer, especially in family law, had been informed about the nuances of coercive control and that as an indicia of abusive relationships. But even beyond family law, think about trauma-informed lawyering and informing yourself about violence against women and how that might affect, for instance, corporate structures and sales of shares, real estate transactions where a spouse has to consent. It basically might touch every aspect of your practice, even if you're not in the family law area, because you want to be sure that your clients are voluntarily engaging in transactions. Wills also. Um, Being a good sex gender equality ambassador, in public discourse. I kind of feel alone out there sometimes when I'm writing about things in my column. It would mean a lot to have other members of the profession engage, whether that's tweeting on social media, newsletters from law firms, talking about issues like pay transparency, coercive control, extending pay equity to the private sector. And the do one thing. I was talking to the CBA midwinter meeting in New Brunswick just the other day about the doing the one thing, because a lot of these issues and barriers seem overwhelming. So just pick one thing that you can do and say, this is something concrete that I will commit to doing. And you can even do it before you leave today. And that I will commit to seeing if I can do this one thing that I think will advance gender equality or sex equality. And the one thing I was talking about to the CBA wasn't even about sex equality specifically. It was about me feeling overwhelmed and depressed and discouraged about the war in Ukraine, because that's my family background is Ukrainian. And I thought if I could just do one thing, it would be about bringing a Ukrainian scholar to our law school. And I said, the one thing I'll do is ask my dean about it. I was fully expecting him to say, no, we don't have the resources. But amazingly, he said yes. And we brought a Ukrainian scholar to Canada along with her mother to stay for a 4-month fellowship, which turned into a 6-month fellowship. And I was able to also use my connections to refer her to a law firm where she's working now. And she'll be off doing her PhD this upcoming year at McGill. So that was a good news story that just came about from the one thing I thought I could do. So I will leave it at that. Maybe we can go into questions about any or all. This has been kind of a lot of information being thrown at you.
Thank you so much, Professor Froc. That was a fascinating presentation, and I know that everyone on the call will have takeaways from that presentation and discussion today. And I hope that we all indeed do have concrete steps that we can take to advance gender equity today and every day. Open the floor up for questions and comments. You can either type a question in the chat or you can raise your hand and speak directly to Professor Froc.
And sorry for the snoring in the background. It's my elderly Boston Terrier.
Who we could not hear.
Oh, that's good because she's like really loud.
So I don't have any questions coming from the floor. So maybe I will get it started and then invite
Okay.
others to join. Early in your presentation, you mentioned the concept of implicit bias. I took careful note of your best practices that you recognize in terms of being a champion and being inclusive and committed and passionate. Do you have any recommendations in terms of addressing implicit bias in law firms? It's a struggle that we're all still learning. We all have lots of room to learn on this issue. So I'm always interested in comments in that regard.
Hmm. Well, I've been away from the law firm private practice for quite a while now, so I kind of feel like, I want to kind of throw ideas around with you rather than, saying, well, you should do this and that. But one thing that I was reading in the Harvard Business Review is it really comes down to law firm leadership, um, doing the work to educate themselves about structures of power, like racism and sexism, and how those structures might be perpetuated. The one thing that I find doing constitutional law is the effects of those things linger well after the initial prejudice, right? So we might get these things perpetuated into law or to policy or practice where we've lost the connection as to why we really do them, and they might have some real problematic effects. So again, things like moving towards difference, thinking about um, the associations, the halo effect. I just remember from my old firm, there was one associate that was known as the scholar because he had published, one paper in a law journal. I was not recognized as the scholar, but it's interesting how, these kind of auras come about people, and you really have to consciously sort of, talk to yourself about, what is true. Is there any connection between what I think and what is true? I mean, Erin Reeves talks about, in her book, the confirmation bias. And are we really interpreting and looking for things to confirm what we already know rather than things that challenges our perceptions? Overconfidence bias, extreme confidence in our own answers because they comport with our experiences, and the notion that you really have to be open to hearing other people's experience. Illusory correlation, seeing relationships between two or more things when none exist because of prejudice or our own interpretations. Or the false consensus effect, overestimating how many people actually agree with us just because we haven't asked people and the other people are staying quiet. So, and this is what the Harvard Business Review and what I was researching, they say that that's the really hard part is, we can have all of these great policies and, attempt to address some of these things in our structures. But unless we change the way we think, and the people at the top do that really hard work in addition to the, however many hours, the 2,000 hours they have to bill a year, and all the administration they have to do from, in the firm. It's, it's the really hard work that possibly should be built in the compensation structures to recognize people that are willing to do the work. And that's the way it'll get done.
Thank you so much for that. Those are very important comments. We do have a question from Gavin, and of course today is the theme today is to embrace equity for International Women's Day, and this question goes directly to that concept. So Gavin asks, could we perhaps have a real world, for instance, of practices which are equal but not equitable? With thanks. And I always think of that fence with the people on the different size stools looking over the fence in terms of the difference between equality and
Right.
equity. But I
Yeah.
would really welcome your comments on that issue.
Yeah, and that, I was looking at that meme the other day and where it came from. And, it's kind of been tweaked over the years because it really comes from Americans, and equity is really more something that Americans talk about because their notion of equality is very formalistic. In the Canadian context, at least in the constitutional context, we talk about formal and substantive equality. And it's not the good equality and the bad equality. They're both important because when we think about formal equality, it's equal treatment, treating people equally. Same-sex marriage came out of formal equality. Why shouldn't people who want to marry someone of the same sex be able to marry? Substantive equality is when you have aspects that seem to be equal, but they're not and they seem to be neutral and objective measures, but they're not really. So for instance, one is billable hours. That seems neutral and objective. It's, you know, whatever you bill, and everyone has the same amount of hours in the day. But the question is that really an objective measure, or are there things that are embedded in it that pose barriers for women? I mean, the old one, that we talk about is the fact that women might have childcare responsibilities, which mean that they can't fulfill that in the same number of hours. So they really don't have the same number of hours as to devote as men. But we're in the practice of law. That's where we get our money from, is our hours of work. So I think what you want to look at is other things as well. Do women have the equal ability to get the files where they can bill a lot? Do they have the equal ability to engage with important clients, to build those relationships and get those legacy clients turned over to them? I'm not going to try to reinvent the wheel to say the billable hour should not be used. There's been other people that have talked about that. But if you're going to keep with the billable hour, think about who could be a star on this file, who could be a star at cultivating client relationships, and look beyond similarity and cultivate that in people that you might not otherwise see. My husband was a vice president, yes, at Carleton. And one of the programs he had was a leadership program for to increase diversity in senior management positions. And one thing that he had to become aware of is that a lot of time women need to be asked. Women need to be asked if they want to go up for promotion. They need to be asked whether or not they want to be a part of leadership, because they don't necessarily see themselves as leaders. For instance, for job applications, the studies show that men will apply even if they don't have remotely near the qualifications that the ad looks for. Women won't apply if they don't have one or two. So think about that in advertising for positions. Think about that in terms of asking people that might not have all the qualifications, but might do a great job. So those are the kinds of concrete things that I would suggest. And also, like, get this book. Honestly, it's a really great book. Aaron Reeves, The Next IQ. I can't recommend it enough. I think it would be well worth your time to read it. And it's a short and a very accessible read.
Thank you for that advice, and thank you, Gavin, for that excellent question. Any other questions from the floor, the group? I have another question. So we're here on International Women's Day, and obviously we're focusing on women's issues. We definitely do recognize the challenges that women who are also members of other diverse groups face, and that those challenges of that intersectionality. Do you have any
Mm.
comments on that issue as we seek to learn more about it and to grow in that area?
Yeah, and that's something, frankly, that we're dealing with in the law faculty as well. For instance, what affirmative action programs show is that it's mainly white women that benefit from them. So in terms of, I would say have a deeper understanding of diversity in terms of looking at intersectionality. Intersectionality is the idea that, for instance, it came out of Kimberly Crenshaw, who said that Black women might experience discrimination, which is completely unlike this discrimination that white women face and Black men face. So you have to be sensitive to that. But I would also say look at the issue of what's been called covering. There was a book that was written on that in the context of constitutional law, but I think it's applicable. What covering refers to is the idea that we maybe get people that look different um, and are diverse, quote unquote, but we only value and promote them when they behave exactly the same as the dominant group does. So I would say that for diverse women in particular, interrogate your, what looks like quality and merit. Think about whether or not the differences that are allowable are simply those where the behaviors of those are of white men, and whether or not the firm can be more flexible in terms of what that looks like. And I would say also be careful about channeling diverse women into certain areas, such as, if we have someone that's Asian, well, maybe they can develop more clients in the Asian market. They may have no interest in that particular, and it kind of makes people feel like they're, being instrumentalized rather than being accepted for their own merit and on their own, skills and abilities. So those are some of the things that I've been thinking about.
Thank you so much. We are at 12 o'clock, but we do have some additional time. I see Gavin has posted a thank you in the chat, so thank you, Gavin, for that comment. Lynn has also posted a link to Erin Reeves' new book called In Charge, so thank you
Oh,
for that, Lynn. Sharon has a question, Professor Froc. Could you elaborate on the pay bands mentioned? The legal profession has many women not only working as lawyers, but as staff.
mhm. Yeah, so what pay transparency calls for is for you to explicitly put in the advertisement the pay band for the particular position. So it can be, and what they should be is pay bands that are realistic rather than, the pay can be anywhere from 20,000 to $100,000. Make the pay bands based on, the actual experience of, the most senior and the entry level positions. So that people get a real sense of what the position pays. So, that's what I would suggest is, try that out. See if it results in an improvement in both in narrowing the gap or identifying gaps in your own firm and the quality of applicants. Because they know going into it what the job pays. So, that might mean a better match where people don't come in with an inflated sense on what the position might pay. And like I say, I was astonished that the data shows that it would have such an effect on the pay gap. But the data is there. The only thing and the only qualification to that is there's some data showing that it might have a flattening effect with some of the high flyers and people that earn at the top rung, because in order to make everyone's pay, in the pay transparency, some employers might hesitate at posting, the very highest pay because they think everyone will want that. But if your systems are truly neutral and objective, then that shouldn't be occurring.
Very interesting.
Hmm.
Angela has her hand up. Angela, go ahead.
Hi, Kerri, and thank you so much. This was excellent. I just found this so helpful and just made me think through, what we can do that's more concrete and great discussion about, what we can do as an organization. I'm really curious to hear your thoughts. We have a lot of allies that support women and women identifying members at our firm, and I feel very supported. And I think our women support women strongly at the firm. And I'm just
Mhm.
curious what practical tips you'd have for us as colleagues and how we can support women and women identifying members of our firm better on a day-to-day
Yeah.
basis.
And, I was thinking about, the kinds of things that I hear from our law students. And I would say, think about different personalities. Like we have one of my students that was coming into a law firm felt this massive pressure, even as a law student, to come out to all the law firm events and even informal ones. She was taken to lunch by a couple of associates who, and she felt very kind of targeted because they said, we don't think that you're going to be a good fit here because you don't go out for drinks with us, you don't do this and that. So I would you know, as I say, I think it's about, you know, accepting difference, accepting that people might have different ways of connecting. Going out for drinks, what does that mean to a person that's a non-drinker, for instance? Are there different ways that you can build, you know, kind of camaraderie and teamship that are different than the same old that we're used to doing? You know, and, you know, that student of mine, she was a brilliant student. She went off and clerked at one of the Ontario courts, and that law firm lost her because she had such a negative experience. That's what you don't want to do. You don't want to be losing talent like that, right? So I think, you know, look at, yeah, just try to tailor yourself to people from different experiences and different, you know, paths that they're on.
That's very helpful. Thank you for sharing.
Then we have another question from Renat. I'm not sure I'm pronouncing your name correctly. Oh, you may be on mute.
Hi. Yes, sorry, the perils of technology. I turned on my camera, but the cover was off, and then I forgot to unmute myself. I fully agree with you, Professor, the way you said it, that what does going out and drinking mean for people who don't drink, right? So,
Yeah.
and as an immigrant, and I can say this for a fact, that the small gestures that we do with even good intentions sometimes does not help the other person feel included. For example, very small thing like immigrants like us have no knowledge of hockey or ice hockey, right? But in the small talks, when hockey comes up or ice hockey comes up, we struggle. We struggle to connect. We struggle to even feel part of that conversation or included, right? The intention was absolutely right that they wanted to have small talks to include us, but unfortunately, the background wasn't checked that is this even a valid part of conversation with this person. So I think being an inclusive culture is all about being really, really aware who your parties in the conversation are, and tailor make it, like you said, like keep tailoring it to the need of the people in your organization. I know it'll be impossible to customize for each and every interaction, but as much as we can.
Yeah. Well, it's interesting you mentioned that. And even, you know, like I'm not, you know, I'm a third generation immigrant. But I remember one of the senior partners at my old law firm was inviting some of the male associates to go and watch like a boxing match that was on pay-per-view. And like I have no interest in boxing, but what was happening at these kind of informal get-togethers is files were being discussed and handed out and all the rest of that. And so, you know, when I was asking about it, they're like, well, we know you're not interested in that. And that's true, but I am interested in getting the work. So, you know, and it's those kind of, yeah, it's, you know, it's about bringing up to consciousness, you know, the fact that, you know, people are from different backgrounds, and what does that mean? And, you know, even the informal things can make make big impact on people's trajectory.
Right.
Right. Yeah. How do you pronounce your name? Is it Renat?
Renat.
Renat. Yeah. So
Yes.
thank you for that. That
Thank
was
you.
really helpful.
Thank you.
Thank you, Renat. Other questions or comments?
Thank you.
No, so
Great.
perhaps over to Andrea.
Oh, sorry. It's Andrea. Yeah, no, one thing that I was thinking about during your presentation, Kerri, is just sort of the prevalence of the imposter syndrome, and how that surfaces. And maybe this is an assumption, but more frequently among women. And I was thinking about it in the way that you were describing that example for Gavin about, you know, having to be asked. And it was something that one of our former members who presented on International Women's Day a few years ago, the former Justice Linda Lee Oland, talked about. You know, moving to the bench was not something she had ever really considered, and that she needed to be asked, whereas the men
around her were more sort of naturally gravitating towards that opportunity. So is it something that you see in law students and in your practice? And how do we really proactively combat that sense of sort of imposter syndrome?
Yeah, well, some of it is, I always say the longer I live, the less imposter syndrome I have, not because I'm more, convinced of my abilities, but I can see behind the curtain more that, people that are more senior in terms of our university administration, I think, yeah, I could do that. So I think it's about what I was talking about before in creating cohesive teams. And part of that is, talking about vulnerability, and not in the terms of like having to bare your soul, but, having senior people that are willing to express, I don't have all the answers. And especially when you're dealing with diverse teams, to say that, I have no idea what what your needs are in a particular circumstance. Can you help me here? I think that to have senior leadership show some more of that honesty and vulnerability, I think is a great help at having, having women see that, they're exactly where they should be. They have the skills and the wherewithal to succeed, that they aren't any different necessarily. They have less experience maybe than some of the senior members, but fundamentally they're not that different.
Thanks, Kerri. We were talking before others joined about having t-shirts or buttons. I think maybe we should have like a "you can do that" button for all of our women members. We did have one little thing that we wanted to do before we sign off. Is it okay if we do that, Sarah? So we had, and it's quite fitting because you referenced two really great books. And so we had invited nominations of Equity Embracers, and the prizes that these individuals will receive is a gift card to Indigo. We chose Indigo because it was founded by a very strong female entrepreneur. So I just want to announce the winners. There's 2 per office and then 2 firm-wide. So we'll start with the firm-wide winners. We have Raylene Langor and Melissa Evans, both here in our Halifax office. In Charlottetown, we have Shirley Gomez and Donna McEwen. In Fredericton, this is exciting. We have 2 men, so 2 allies, Parker Menzies and Rob Baird. In Halifax, Julie Robinson and Renee Thompson. In Moncton, another male ally, Chris Borden and Kim Collier. In St. John, we've got Amelia Warren and Emily Schulten. St. John's, Amanda Hurley and Morgan Chafe. And in Sydney, another male ally, Dwight Rutherham and Janet McNeil. So congratulations to all of our equity embracers. You are the champions that we need to be. So thank you for all of your commitment to uplifting all of our members who identify as women.
And I recognize some names of some old students, so I'm very proud of them as well.
Thank you for holding that memory. That's impressive. Okay, well, with a few minutes, just a couple minutes to spare, I will thank everybody for joining on behalf of the DEI Educate Action Team, and sincerely thank you, Kerri, for your time, your expertise, your knowledge, and in your encouragement. And we will be making a donation on your behalf to the National Women Lawyers Association.
Yeah, National Association of Women in the Law.
There you
Yeah,
go.
I'm really thankful that you'll do that. We make every dollar count at that organization. That's, if you want your money used wisely, give it to a feminist organization. They know how to squeeze that lemon.
All right. Well, we'll be
And
sending a nice lemon their way.
yeah. And thank you very much again. I'm really pleased that you know, we had such an engaged audience. And again, thank you to you, Andrea, and Sarah, for that kind introduction and kind and professional mediation of the questions. So thank you very much.
Well done. Happy Women's Day, everybody.